Welcome to this Leadership Squared video titled, What Employers Can Expect for 2021, What Employment Issues Lead to EEOC Charges. I am your host, Jack McCalman. I am an attorney and the founder of the McCalman Group. The McCalman Group provides resources to help employers lower their exposure to employer and management liability risks. This is our fourth Leadership Squared production in our What Employers Can Expect series for 2021. Our first production, titled What Employers Can Expect for 2021, Mandating Vaccinations, examined the litigation risks related to mandating vaccines. Our second production, What Employers Can Expect for 2021, EEOC Litigation Frequency and Severity, discussed the recently released EEOC enforcement and litigation data and what it could mean for employers heading into 2021. For the third production, titled What Employers Can Expect for 2021, What EEOC Charges Are Employees Filing, analyzes the specific charges employees brought against their employers. You can find all three productions on your sponsored platform. In this final production of the 2021 What Employers Can Expect series, we are taking another look at the U.S. Equal Employment Opportunity Commission enforcement and litigation statistics for fiscal year 2020 and discussing the employment practice issues that are most likely to lead to EEOC charges. You can find the information we are analyzing online at eeoc.gov. As stated in the previous productions, the EEOC enforcement and litigation data is important because it provides insight into the equal employment risks in the United States. The statistics help us better understand the frequency and severity of equal employment charges, the types of equal employment charges employees are filing, what types of equal employment charges present the greatest financial risk, and what type of employment issues are most likely to lead to equal employment charges. The EEOC data does not address all employment practice risks. The data focuses on charges related to the nation's equal employment laws, including the Age Discrimination in Employment Act, the Americans with Disabilities Act, the Equal Pay Act, the Genetic Information Non-Discrimination Act of 2008, and Title VII of the Civil Rights Act of 1964. According to the EEOC 2020 statistics, the statute employees most often file charges under is Title VII of the Civil Rights Act of 1964, followed by the Americans with Disabilities Act. Beyond the statute, the EEOC narrows the issues even further and lists areas of employment that serve as the basis for EEOC charges under the equal employment statutes, including, but not limited to, advertising, assignment, benefits, constructive discharge, discipline, harassment, hiring, promotion, reasonable accommodation, sexual harassment, terms and conditions, training, wages. What I have listed is a partial list. For the full list, go to eeoc.gov. In 2020, the issue that was the foundation for most EEOC charges was discharge, meaning when an employer terminates the employment relationship with an employee. If an employee is discharged and files a charge with the EEOC, retaliation is the most likely claim asserted. There were 22,281 charges of retaliation, which listed discharge as the reason for the charge. Disability, race, and sex discrimination charges are the next most likely ones an employee may file with the EEOC after being discharged. There were 15,193 charges of disability discrimination, 11,331 charges of race discrimination, and 9,930 charges of sex discrimination that alleged discharge as the basis for the charge. Listed by the EEOC and related to discharge are constructive discharge and layoff. Like discharge, both in the employment relationship. A constructive discharge occurs when an employee quits because working conditions are so intolerable that a reasonable person would voluntarily terminate their employment under the same circumstances. A layoff occurs when an employer suspends or terminates an employee for reasons other than job performance. A layoff can be permanent or temporary. There were 3,378 retaliation charges that listed constructive discharge as the reason a charge was filed, and 701 that listed layoff. When you add the number of charges brought for constructive discharge and layoff to the discharge numbers, it is clear that when an employer terminates or suspends its relationship with an employee, the employer is at its highest risk for an EEOC charge and, in particular, for retaliation charges. Another issue that can spark an EEOC charge is harassment. In fiscal year 2020, 20,362 charges were brought under Title VII for harassment, including sexual harassment. Harassment and/or sexual harassment was alleged in 11,497 sex discrimination charges under Title VII, and 6,426 charges were brought due to sexual harassment alone. Retaliation charges were brought due to harassment and/or sexual harassment in 12,373 cases. Charges of race discrimination were alleged in 8,476 cases, listing harassment as the issue. The broad category terms and conditions is another common issue that resulted in EEOC charges, although nowhere near the levels of issues related to terminations. Terms and conditions can include broad opportunities related to employment, such as policies, procedures, and job duties. A total of 22,586 charges were filed under all equal employment statutes for claims related to terms and conditions of employment. However, not all issues get the attention of employees. For example, there were only 1,112 race charges, where hiring was listed as an issue in 2020. Additionally, only 1,762 sex discrimination charges were filed where wages were an issue. So, what can employers expect in 2021? Employers can continue to expect that if they discharge or lay off an employee, or if an employee alleges any form of harassment, that the chances for an EEOC charge will be significantly higher than for other issues. To avoid charges related to terminations, employers should closely evaluate every discharge and layoff to make certain that others would view the actions as without bias and as neutral. There should always be objective evidence that justifies the reasons for all terminations of employment if you desire to lower your risk of litigation. Any termination, even of an at-will employee, that cannot be explained objectively with documented evidence is far more difficult to defend when questioned by the EEOC or anyone else. As for harassment, employers should make it easy for employees to report harassment without fear of retaliation. Employers should be ready to investigate allegations and/or reasonable suspicions of harassment in a thorough, prompt, and objective manner. Thank you for watching this Leadership Squared video. What employers can expect for 2021? What employment issues lead to EEOC charges? Stay tuned for more Leadership Squared videos. If you would like a transcript of this video, contact the McCalman Group at 918-712-7667 or at mccalman.com. MCCALMON.com. This is Jack McCalman of the McCalman Group, wishing you a safe, healthy, and litigation-free workplace.